Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. Lawyer John E. Deaton has speculated that the action brought by the SEC against Ripple might reach the U.S. Supreme Court before Congress establishes a regulatory framework for the cryptocurrency business. This matter is now pending in the district court and would have to make its way through the Circuit Court of Appeal before making its way to the Supreme Court. The creator of CryptoLaw made this point clear in a tweet earlier today. It came in reaction to evidence that the SEC had no intentions to put the brakes on its rapid crypto enforcement activities. Fox Business's Eleanor Tarrant quoted from the SEC's proposed budget. The government makes it clear that it will investigate and take enforcement action against any cryptocurrency company that it finds to be non-compliant. Based on this, Tarrant concludes that the regulator plans to increase the size of its crypto enforcement section, which has already increased in size over the last year. Deaton, referring to Tarrant's research, states once again that the next 2 years will provide no definitive answers on cryptocurrency outside of the legal system. Notwithstanding his admission that the situation is less than ideal, he insists that it is the truth as it now stands. The Supreme Court may consider the Ripple case before Congress acts, Deaton said on Twitter. We have to go to court and fight this. As Deaton predicted in January, the only clarity the emerging market would receive in the next 2 years would come from the widely awaited verdict in the Ripple dispute over whether XRP is an unregistered securities. The attorney backed up his claim by saying that members still have a bad taste in their mouths after the FEX failure, which has contributed to the partisan divide in Congress. According to the lawyer for thousands of XRP investors who is acting as a friend of the court in the SEC action against Ripple, the approaching judgment by Judge Annalisa Torres grows more momentous with each passing day. While he acknowledged that the federal court may be wrong, he was certain that secondary market XRP sales do not constitute unregistered securities because of his no-way belief. As Judge Torres is a stickler for the letter of the law, Deaton claims there is no precedent to follow. No way the judge accepts the SEC's unlawful notion that the asset itself is always an investment contract. Deaton tweeted, "A similar conclusion has not been reached in any instance in the 8 decades since Howard. A strict legalist, Judge Torres never strays from the letter of the law. That secondary sales are a violation of Section 5 is not something she will determine." According to reports, Deaton thinks the SEC's case against Ripple hinges on the fact that the blockchain payments company offered XRP as a security between 2013 and 2017. Judge Torres issued her decision on the Daubert petitions last week, which sought to exclude expert evidence. This was seen as a win for Ripple, and the company's general counsel, Stuart Alderodi, said they feel more secure with each victory. Judge Deaton's decision on summary judgment is expected shortly. According to Deaton, with the completion of the highly known Securities and Exchange Commission (SEC) lawsuit against blockchain startup Ripple presumably inching closer, a pro-XRP legal expert has offered his thoughts on the case's likely outcomes. Likewise, in a March 10 Twitter thread, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, enumerated 5 probable possibilities for the lawsuit's resolution, including summary judgments, the prospect of settlement, and following lawsuits. In particular, the legal expert said that the regulator did not have anything near the evidence to demonstrate they intentionally or carelessly marketed an unregistered investment in the summary judgment phase involving Ripple CEO Brad Garlinghouse and co-founder Chris Larson. About Ripple's summary judgment on foreign sales, Chamberlain noted that Ripple's sales of XRP on overseas exchanges are not within the court's jurisdiction, adding that an entirely new precedent would be formed to declare those domestic transactions closed in the U.S. Moreover, Chamberlain emphasized that this complaint might lead to a limited case that investigates whether any of Ripple's sales of the XRP cryptocurrency in the United States constituted an unregistered investment contract. In other news, New York Attorney General Letitia James filed a lawsuit against KuCoin, accusing the cryptocurrency exchange of unlawfully functioning as a securities and commodities broker, dealer without registering with the state, as Finbold reported. Scott Chamberlain, a former lawyer and co-founder of Evernode, a proposed Layer 2 smart contract technology for the XRP ledger, has published his 5 predictions for the result of the SEC action against Ripple. To begin, the co-founder of Evernode thinks the SEC will lose its case against Ripple executives Brad Garlinghouse and Chris Larson. Remember that the SEC had identified the executives in their lawsuit against Ripple, accusing them of aiding and abetting the offer and sale of unregistered securities, XRP. According to crypto law, founder attorney John E. Deaton, the SEC must demonstrate that the executives were reckless in failing to recognize that XRP was a security. The SEC, according to Chamberlain, lacks the evidence to substantiate this. Second, Chamberlain believes the court will rule that Ripple's offshore sales of XRP fall beyond the scope of the court's authority. The former attorney said that classifying them as transactions done in the United States would establish a new precedent. In his last forecast, the former lawyer claims that the only question is whether any Ripple XRP sales in the United States contained an unregistered investment contract. Because of his second and third forecasts, Chamberlain anticipates that the SEC will seek a settlement. According to the former lawyer, the SEC overlooked the fact that the majority of Ripple's XRP sales happened offshore. With the lengthy legal struggle coming to a conclusion, at least at the district level, it is predictable that speculation about its fate has reached fever pitch. Chamberlain's projections, for the most part, agree with Deaton's prior forecasts and analysis. Significantly, the attorney projected that there would be no out-of-court settlement until after a summary judgment finding to delay a prospective trial or appeal. Moreover, the crypto law creator has said that the SEC's only potential triumph would be if Ripple traded securities between 2013 and 2017. As a result, he thinks there will be no disgorgement or injunction on XRP sales, but Ripple may be required to pay a fine. The cryptocurrency world is anticipating the summary decision in the legal action between Ripple and the Securities and Exchange Commission, with the ruling expected by the end of March. In the most recent update, United States lawyer Jeremy Hogan stated in a tweet on March 9 that presiding judge Annalisa Torres may have already ruled whether XRP is a security. Hogan, a pro-XRP lawyer, reached this conclusion after noting that the judge mentioned the securities law case Marine Bank v. Weaver at least 3 times in her most recent judgment when describing the viewpoint of XRP holders who purchased the coin. Hogan also released an extract from the lawsuit, wondering if what was offered was commonly recognized as a security. The court addressed the Marine Bank v. Weaver case at least 3 times in her latest order when addressing what a reasonable XR purchaser thought when they purchased XRP issue. The lawyer's allegation comes after Judge Torres issued a 57-page ruling on the dollar bear applications made by both parties to exclude expert evidence from the summary judgment. According to the verdict, neither Ripple nor the SEC are the winners, since the court approved and refused elements of each party's request. Judge Torres rejected the SEC's top expert witness, Patrick Doody, who was entrusted with examining XRP purchasers' expectations. Nonetheless, Ripple's experts on the distinctions between Ripple's contracts and those in the Howard case, the tax treatment of XRP, the accounting treatment of XRP, and currency experts on XRP were all permitted to speak on the record. Despite the absence of a clear winner in the Daubert motion's judgment, Ripple's chief legal officer Stuart Alderodi stated that the conclusion was in favor of the payment service and that he was confident in the case. As we have indicated throughout, we have always been confident about our case, and with each judgment, we have become even more so, Alderodi added. At the same time, pro-XRP lawyer John Deaton feels the SEC made a big mistake in identifying Ripple executives Brad Garlinghouse and Chris Larson in its enforcement action against the business. According to Deaton, the SEC should have focused only on Ripple, the firm that issued XRP, rather than prosecuting people who were not directly responsible for the alleged securities breaches. Deaton first claimed that the judge in the case criticized SEC attorneys of putting their interests ahead of enforcing the law. The lawyer questioned the SEC's capacity to properly enforce the law if its agents refused to do so. According to Finbold, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, predicted that the lawsuit will most likely have 5 outcomes. Chamberlain predicts that the case will be settled, establishing precedents on the classification of XRP as a security and the court's authority over sales made outside. Earlier, Ripple sent a statement in support of their fair notice defense, citing a recent Supreme Court decision. The submission was made in response to a judgment that limited the U.S. government's authority to levy fines on us taxpayers who do not reveal their offshore bank accounts. Ripple stressed the need of federal legislation creating clear limits on what behaviors are forbidden, emphasizing the necessity for regulatory certainty in the cryptocurrency business.